I'm going to ask you a series of questions, some of which just ask for yes or no. To the extent that you can do that, I'd appreciate it, but you can do whatever you want to do. How's that? General Kagan, I want to begin by discussing freedom of speech in general and campaign finance reform in particular. As you know, the first word in the First Amendment is Congress. I know that the Supreme Court has said that the First Amendment also limits state government, but do you agree that the America's founders were first concerned about setting explicit limits on the federal government in areas such as freedom of speech?
There's no question that the First Amendment limits what Congress and what other state actors, executive officials, and can do.
Okay. The Supreme Court has said that the First Amendment protects some types of speech more strongly than others, and even that it does not protect some types of speech at all. Do you agree that the Supreme Court has held repeatedly that political speech, especially during a campaign for political office, is at the core of the First Amendment and has the First Amendment's strongest protection?
Political speech is at the core of the First Amendment. I think that has been said many times by the court.
Yeah, I think one of the great examples, you versus San Francisco County Democratic Central Committee back in 1989, really came out very strongly on that. When you worked in the Clinton White House, you wrote a memo in October 1996 in which you wrote this, quote, "It is unfortunately true that almost any meaningful campaign finance reform proposal raises constitutional issues. This is a result of the Supreme Court's view, which I believe to be mistaken in many cases, that money is speech and that attempts to limit the influence of money in our political system therefore raise First Amendment problems," unquote. Now, as I understand it, President Harry Truman argued as far back as 1947 that a ban on independent expenditures would be, quote, quote, dangerous intrusion on free speech, unquote. The notion that spending and speech are necessarily related is hardly new and hardly confined to the Supreme Court or even one political party. Do you recognize, or excuse me, do you reject the idea that spending is speech?
Senator Hatch, the quote that you read, I believe, was not written by me in my voice. It was a set of talking points that I prepared for, I'm not sure if it was for the president, for President Clinton, or if it was for the press office, but it was meant to reflect the administration's position at the time. The administration was trying very hard to enact the McCain-Feingold bill, and those talking points were in service of that objective, and so they weren't, my personal constitutional or legal views or anything like that, but was just a set of talking points that I prepared for, I think it was the press office, it might have been for the president himself.
Well, you were listed as the creator.
I created a lot of talking points in my time.
Okay, I accept that. I want to turn to the Supreme Court's decision in Citizens United versus FEC for a little bit. I've seen media reports that in a meeting with at least one of your colleagues on this committee, you said that you believed the Citizens United case was wrongly decided. Is that true?
Senator Hatch, I argued the case, of course. I walked up to the podium and I argued strenuously that the bill was constitutional.
But I'm asking about your belief.
And over the course, at least for me, when I prepare a case for argument, the first person I convince is myself. Sometimes I'm the last person I convince, but the first person I convince is myself. And so I did believe that we had a strong case to make. I tried to make it to the best of my ability.
Okay. The statute being challenged in this case prohibited different types of for-profit corporations, non-profit corporations, and labor unions from using their regular budget to fund speech about candidates or election issues within 30 to 60 days of a primary or a general election. They could form separate organizations called PACs, political action committees, to do so, but they did not have the freedom to use their own money directly to speak about candidates or issues as they saw fit. Now, I know there's a lot of loose rhetoric about the decision in this case allowing unlimited, quote, spending on elections, unquote. I assume that that is to conjure up images of campaign contributions or collusion. But just to clarify the facts, the statute and the Citizens United case involved what are called independent expenditures, or money spent by corporations, nonprofit groups, or unions completely on their own to express their political opinions. Now, this case had nothing to do with contributions to campaigns or spending that is coordinated or connected in any way with candidates or campaigns. Isn't that true?
You're right, Senator Hatch, that this was an independent expenditure case rather than a contributions case.
When President Obama announced your nomination, he said that you believe that, quote, in a democracy, powerful interests must not be allowed to drown out the voices of ordinary citizens, unquote. Virtually all of the rhetoric surrounding this case is focused on large for-profit corporations, but the law in question, and of course, this case affected much more than that. As you know, in that case, a nonprofit organization sued to defend its freedom of speech rights. Do you agree that many people join or contribute to nonprofit advocacy organizations because they support the positions and message of those groups, and because those groups magnify the voice of their members and their contributors?
I do agree that civic organizations are very important in our society, Senator
These aren't
Hatch.
just civic organizations. I'm talking about unions and businesses and nonprofits and profits and partnerships and, S corporations and a lot of others.
Yes, you're right that the statute that the government defended in the Citizens United case was a statute that applied to many different kinds of corporations. And one of the things that the government suggested to the court in the course of its arguments was that one possibly appropriate way to think about the case might be to treat those different situations differently. But the statute itself applied to many different kinds of organizations.
Okay. Now, President Obama called the Citizens United decision, quote, a victory for powerful interests that marshal their power every day in Washington to drown out the voices of everyday Americans, unquote. Now, as I said, the statute applied to for-profit corporations, nonprofit corporations, and labor unions. Do you believe that, let's just take unions, do you believe that they are, quote, powerful interests that drown out the voices of everyday Americans?
Senator Hatch, what the government tried to argue in that case was that Congress had compiled a very extensive record about the effects of these independent expenditures by corporations generally and by unions generally on the political process. And that what the Congress had found was that these corporations and unions had a kind of access to congressmen, had a kind of influence over congressmen that changed outcomes, that was a corrupting influence on Congress. And that was what the many thousand-page record that was created before Congress enacted the McCain-Feingold bill revealed, and that's what we tried to argue to the court.
I understand the argument, but the statute banning political speech that was challenged in Citizens United also applied to small S-chapter corporations that might have only one shareholder. There are more than 4.5 million S-corporations or S-chapter corporations in America. We have 56,000 in my home state of Utah alone. These are small companies who want the legal protections that incorporating provides. These are family farmers, ranchers, mom and pop stores, and other small businesses. Before the Citizens United decision, these small family businesses could be barred from using their regular budget for, say, a radio program or even a pamphlet opposing their congressman for his vote on a bill if it was that close to an election. Do you believe the Constitution gives the federal government this much power?
Senator Hatch, Congress determined that corporations and trade unions generally had this kind of corrupting impact on
all of these 4.5 million small corporations as well.
Senator Hatch, of course, in the Solicitor General's office, we defend statutes, and Congress determined.
No, I understand that. Let me ask my questions the way I want to. I will. I'm going to be fair. I intend to be. And you know that after 34 years. Go ahead, I keep going. Did you have something else you wanted to add?
No, go ahead.
Okay. We have to have a little back and forth every once in a while, or this place would be boring as hell, I'll tell you.
And it gets the spotlight off me, you know, so I'm all for it.
I
Go
can
right
see that.
ahead.
And by the way, I've been informed that hell is not boring, so you can imagine what I mean by
Just
that.
hot.
Okay. I have the current volume of the Code of Federal Regulations. Now, this is governing federal campaign finance. It's 568 pages long, this code. This does not include another 1,278 pages of explanations and justifications for these regulations, nor does it include another 1,771 Federal Election Commission advisory opinions, even more enforcement rulings, and still more federal statutes. Now, let me ask you this. Do you believe that the Constitution allows the federal government to require groups such as nonprofit corporations and small S-chapter corporations to comb through all of this? This is just part of it. Thousands of other pages of regulations. Likely hire an election law attorney and jump through all the hoops of forming a political action committee with all of its costs and limitations simply to express an opinion in a pamphlet or in a radio or a movie, or just to criticize their elected officials. Do you really believe the Constitution allows that type of requirement?
Well, Senator Hatch, I want to say, Senator Hatch, you should be talking to Senator Feingold, but I won't do that. Senator Hatch, Congress made a determination here, and the determination was that corporations and unions generally had this kind of corrupting influence on Congress when they engaged in
independent expenditures. But you acknowledge that it covered all these other smaller groups and all these other groups that should have a right to speak as well.
The Solicitor General's office, of course, defends statutes as they're written, and Congress made the determination broadly that corporations and trade unions had this corrupting influence on Congress. And in the Solicitor General's office, we in the Solicitor General's office, as other Solicitor General's office have done, vigorously defended that statute as it was written.
I understand.
On the basis of the record that was made in Congress, this, I think it was an 100,000 page record about the corrupting influence of independent expenditures made by corporations and unions. Now, the court rejected that position. The court rejected that position in part because of what you started with. You said political speech is of paramount First Amendment value. It's no doubt the case. And the court applied a compelling interest standard, and the court rejected the position. But the position that we took was to defend the statute, which applied broadly.
I have no problem with that, because that was your job. But I'm getting into some of the comments by some of our colleagues, by the President and others, about how wrong this case was, when I don't think it was wrong at all. Your 1996 Law Review article about private speech and public purpose emphasized the need to examine the motive behind speech restrictions. Since you've already written about this, I would like to know whether you personally agree with the Supreme Court in the Citizens United decision that, quote, speech restrictions based on the identity of one speaker are all too often simply a means to control content, unquote. Do you agree with that?
Senator Hatch, speaker-based restrictions do usually get strict scrutiny from the Supreme Court, and for the reason that you suggest, which is a concern about why it is that Congress is saying one speaker can speak and not another. I had a very interesting colloquy with Justice Scalia at the court on this question.
I understand.
Justice Scalia said to me, and it's a powerful argument. He said, well, you know, if you let Congress think about these things, Congress is going to protect incumbents, that might be a reason for Congress to say that certain groups can make independent expenditures and other not.
Well, one part of Congress would protect incumbents. The others would be trying to throw them out. I mean, that's what this system is.
But I said to Justice Scalia, and I think it's true with respect to the McCain-Feingold bill, that all the empirical evidence actually suggests, I think my line was, this is the most self-denying thing that Congress has ever done, because all the empirical evidence suggests that these corporate and union expenditures actually do protect incumbents, and notwithstanding that, in the McCain-Feingold bill, Congress determined that it was necessary in order to prevent corruption to prevent those expenditures. But, the court said no.
Well, tell that to Blanche Lincoln, how incumbents are protected. In this case, the speech in which Citizens United, I think about Blanche Lincoln, one of the nicer people around here, who had $10 million spent against her by the unions just because they disagreed with her on one or two votes. And let me keep going now. In this, and I'm enjoying our colloquy together.
Me too.
In this, I hope so. In this case, the speech in which Citizens United wanted to engage was in the form of a movie about a presidential candidate, Hillary Clinton at the time. The Deputy Solicitor General first argued the case, the Deputy Solicitor General from your office. He told several justices that if a corporation of any size, a union or even a nonprofit group, did not have a separate PAC, the Constitution allows Congress to ban publishing, advertising, or selling not only a traditional print book that criticized a political candidate, but an electronic book available on devices such as the Kindle. Even a 500-page book that had only a single mention of a candidate, not only print or electronic books, but also a newsletter, even a sign held up in Lafayette Park. Now, isn't that what, under that argument at that time, your office admitted that at first oral argument, at the end of the day, the Constitution allows Congress to ban them from engaging in any political speech in any of those forms?
Senator Hatch,
I'm not blaming you for the prior argument, nor am I really blaming the person who was trying to defend this statute. I'm just saying that's what happened.
Senator Hatch, the statute, which applies only to corporations and unions when they make independent expenditures, not to their PACs. But for corporations and unions, when they make independent expenditures within a certain period of an election,
right,
the statute does not distinguish between movies and anything else.
Well, as you can see, I'm finding a certain amount of fault with that. And that's why the Citizens United case, I think, is a correct decision. The court's been criticized, including just yesterday, in this hearing for not deciding the Citizens United case on narrower statutory grounds. But according to some media accounts, such as in National Journal, it was your office's admission that the statute had much broader constitutional implications that prompted the court to ask for a second argument in this case. Now, that's where you come in. You re-argued the case last September, and I believe it was Justice Ginsburg who asked whether you still believed that the federal government may ban publication of certain books at certain times. You said that the statute in question covered books, but that there might be some legal arguments against actually applying it to books. I certainly agree with you on that. But didn't you argue that the Constitution allows the federal government to ban corporations, union and nonprofit groups from using their regular budget funds to publish pamphlets that say certain things about candidates close to an election? You did?
Senator Hatch, I was defending the statute as it was written. And the statute as it was written applied to pamphlets as well as to the movie in the case. And we made a vigorous argument that the application of that statute to any kinds of classic electioneering materials, not books because they aren't typically used to electioneer, but that the application of the statute to any kinds of classic electioneering materials was in fact constitutional, and that the court should defer to Congress's view of the need for this.
I accept that you made that argument, and that you were arguing for statutory enactment by the Congress. But as I mentioned, you said that the federal government could ban certain pamphlets at certain times because pamphlets are, as you put it, quote, pretty classic electioneering, unquote. You said that pamphleteering is classic political activity with deep historical roots in America. Certainly some of the most influential pieces of political speech in our nation's history have been pamphlets such as Thomas Paine's Common Sense. Since in the Citizens United case you were defending application of the statute to a film, would you also consider films as classic electioneering?
Senator Hatch, I'm trying to remember what our brief said, but yes, I think the way we argued the
You took
case,
that position.
it applies to films as well, of course.
All right, a pamphlet is often defined, at least in the dictionary, as an unbound printed work, usually with a paper cover or a short essay or treatise. In another First Amendment context involving the Establishment Clause, Justice Kennedy criticized the idea that application of the First Amendment depended on such things as the presence of a plastic reindeer or the relative placement of a poinsettia. Now, I believe he called that a jurisprudence of minutia. I thought it was an interesting comment myself. Do you believe that the protection of the First Amendment should depend on such things as the stiffness of a cover, the presence of a binder, or the number of words on a page? Now, you can give an opinion on that since that case is decided.
Senator Hatch, what we did in the Citizens United case was to defend the statute as it was written, which applied to all electioneering materials, with the single exception of books, which we told the court were not the kind of classic electioneering materials that posed the concerns that Congress had found to be posed by all electioneering materials of a kind of classic kind. Books are different. Books, nobody uses books in order to campaign. But
That's
with
not
respect,
true. Yeah, that's not true. And you did say the books are probably covered, but you didn't think they would.
I said that the argument was that they were covered by the language of the statute, but that a good constitutional challenge, as applied constitutional challenge, could be made to it, because the purposes that Congress had in enacting the statute, which were purposes of preventing corruption, would not easily have applied to books, but would have applied to all the materials that people typically use in campaigns.
I understand. In 1998, when you served in the Clinton administration, the Federal Election Commission sued Steve Forbes and his company that publishes Forbes magazine. Now, I have a copy of the Forbes magazine right here, and I think most people are familiar with it. Steve Forbes had taken a leave from his position with the company to run for president, but continued writing columns on various issues. The FEC used the same statute that you defended in the Citizens United case to say that these columns were illegal corporate contributions to Forbes's presidential campaign. And I know that the FEC later decided to terminate the lawsuit, and I know that this Forbes lawsuit involved alleged campaign contributions rather than independent expenditures, but the same statute was involved, and I use this as an example to show what can happen on this slippery slope of the federal government regulating who may say what and when about the government. Now, the Forbes case involved a magazine. The case you argued involved a movie. Your office admitted that the statute could apply to books and newsletters. You admitted that it could apply to pamphlets. Now, all of this involves the political speech that is the very heart of the First Amendment, whether engaged in by for-profit corporations, non-profit corporations, tiny S-chapter corporations, or labor unions. Do you really believe, now this is your personal belief, do you really believe, I understand you represent the government, but do you really believe that the Constitution allows the federal government this much power to pick and choose who may say what, how, and when about the government?
Senator Hatch, putting the Citizens United case to the side, I think that there are extremely important constitutional principles that prevent the government from picking and choosing among speakers, except in highly unusual circumstances with hugely compelling interests.
Well, what's highly unusual about a book or a pamphlet or a movie?
Senator Hatch, I said putting Citizens United to the side. I argued that case. I argued it on behalf of the government because Congress had passed a statute.
But you do believe it was wrongly decided, too, don't you?
I'm sorry?
You did take the position it was wrongly decided.
I absolutely said, Senator Hatch, that when I stepped up to the podium as an advocate, I thought that the U.S. government should prevail in that case and that the statute should be upheld. I wanted to make a clear distinction between my views as an advocate and any views that I might have as a judge. I do think Citizens United is settled law going forward. It's no question that it's precedent, that it's entitled to all the weight that precedent usually gets. I also want to make clear that in any of my cases as an advocate, and this is Citizens United or any of the other cases in which I've argued, I'm approaching the cases as an advocate from a perspective of, first, the United States government interests, and also it's a different kind of preparation process. You don't look at both sides in the way you do as a judge.
I got that. I don't have any problem with that. All I'm saying is that we've had arguments right here in this committee that this was a terrible case that upset 70 years of precedent. And we've heard all these arguments, and they're just inaccurate. And that's what we're establishing here. When President Obama criticized the Citizens United decision in the State of the Union address, with the Supreme Court justices sitting there, he said that it would allow foreign corporations to fund American elections. Now, others have said the same thing. Do you agree that this case involved an American nonprofit organization, not a foreign corporation? That this case involved independent political speech, not campaign contributions? And that the separate laws regarding political spending by foreign corporations and campaign contributions by anyone are still in force today?
Senator Hatch, this case did, as you say, these parties were domestic nonprofit was a domestic nonprofit corporation.
Okay. Yeah. Well, there was no foreign corporation involved. That's one of the points I'm trying to establish, and it was a misstatement of the law. Now, I'm not here to beat up on President Obama. I just want to make this point. And yet, colleagues have just accepted that like that's true. It isn't true. In First National Bank of Boston versus Bellotti, the Supreme Court held in 1978, more than 30 years ago, that, quote, the identity of the speaker is not decisive in determining whether speech is protected. Corporations and other associations, like individuals, contribute to the discussion, debate, and the dissemination of information and ideas that the First Amendment seeks to foster, unquote. Bellotti was decided just 2 years after the landmark case of Buckley versus Vallejo. In Bellotti, the court recognized that corporations have a First Amendment right to engage in political speech. In that decision, Chief Justice Berger wrote an interesting concurrence in order to, as he put it, quote, raise some questions likely to arise in the future, unquote. These questions included that large corporations would have an unfair advantage in the political process. He had some amazing insight there, I think, because people are making just such arguments today. That case also involved the First Amendment protection of the press, but Berger noted how the government historically has tried to limit what may be said about it. He concluded, quote, in short, the First Amendment does not belong to any definable category or persons or entities. It belongs to all who exercise its freedoms, unquote. Do you agree with that?
I'm sorry, Senator Hatch.
Do you agree with Justice Berger's comment there?
Would you read that again?
Sure,
I'm sorry.
I'd be glad to. He said, in short, the First Amendment does not belong to any definable category of persons or entities. It belongs to all who exercise its freedoms.
Senator Hatch, the First Amendment protects all of us and grants all of us rights.
Right. And they're important rights. In Citizens United, so I get a little tired of people on the left saying, oh, it was a terrible case, wrongfully decided. When, frankly, let me make this point. In Citizens United, the court listed at least 25 precedents dating back almost 75 years. Here's a list of them right here. Holding generally that the First Amendment protects corporate speech, and specifically that it protects corporate political speech. Now, I'd like to put these cases in the record at this point. On the other side of the precedential scale was a single 1990s decision in Austin versus Michigan Chamber of Commerce. As the court said in Citizens United, no other case had held that Congress may prohibit independent expenditures for political speech based on the identity of the speaker. In other words, Austin was the aberration, the exception. to break in the court's consistent pattern of precedents. And many folks have Mr. Chairman, I'm going to need about 30 seconds more, just to finish here. And then I think
30 seconds more.
Okay. Many folks have attacked the decision, saying it is a prime example of, quote, conservative judicial activism, unquote, because it ignored precedent by overruling Austin. But by overruling that one precedent, wasn't the court really reaffirming a much larger group of previous decisions, including Bellotti, that, as we discussed, affirmed that corporations have a First Amendment right to engage in political speech, and that includes all these small corporations? That sounds like the court is committed to precedent, not rejecting it. Now, I thank my chairman for allowing me to make that last comment, but I get a little tired of people misstating what Citizen United is all about.
Well, Senator Hatch,
I've appreciated your comments here today.
Senator Hatch, I think that there was a significant issue in the case about whether Austin was an anomaly, as you called it, or whether it was consistent with prior precedent and consistent with subsequent precedent as well. And certainly the government argued strenuously that Austin was not an anomaly, although the court disagreed and held that it was.